Erica, thank you for being here today.
Thank you.
On our Ask a Lawyer videos we're doing. The reason we're doing these videos is we get a lot of questions asked by our clients and potential clients about a lot of different things. This one is a question that really goes towards your expertise. So the question today that we're talking about, Erica, is, can I get child support if my ex is not on the birth certificate?
The answer is yes, in a short form. The birth certificate isn't what actually matters. What matters is whether or not there is a voluntary acknowledgement of paternity, which we call it VAP for short. It's a form that's signed at the hospital by presumably mom and dad in front of witnesses, where dad is acknowledging that yes, he is dad, and mom is acknowledging that yes, he is also dad. So they're both swearing under a formal document that they're both parents. Once it's signed, it then goes off to the IVHFS, and then they keep a record of it in case it's ever needed.
Gotcha. Makes sense. So what happens after paternity is established? Does child support just automatically start?
No. So a parent's obligation to pay child support and provide any other support to their child is automatic from the child being born. However, in order to have child support ordered by a court and automatically set a number, the first step is either establishing paternity if you don't have voluntary acknowledgement of paternity. So you would go to court, you file a motion to establish paternity, and the court can order a DNA test, or if dad's willing to admit that he is the father, you can have an impromptu hearing where the court makes sure he's aware of his rights and has him admit under oath that he is father, and mom also admit that he is the father. After you've established paternity, you can move the court for child support. You can file a motion to set child support. If you and your ex aren't married, you can ask for child support retroactive back to the date of birth. So just because you don't file right away doesn't mean you lose that right. However, the court will take into account any payments that have been made for child support from the date of birth, or for anything that, it might not be called child support, but it is basically what child support is intended. So, the basic needs of the child, like clothes, food, diapers.
Gotcha. Makes sense. That's a very clear explanation. Thank you. So, Erica, if somebody is in this situation and doesn't know where to start, what's the first move they should make, you think?
I always recommend contacting a lawyer. I know I'm a lawyer, so I'm going to say that. But step one is determining whether or not they have the voluntary acknowledgement of paternity. A lot of people don't remember if they ever signed it. You can always request it directly from the state. IVHFS keeps a log of it. And if they have it, once you fill out the form and request it, they will send it to you. If they don't have it, then you would move forward with filing a petition to establish paternity. Gotcha. And any other rights that you might want to establish, like the parenting time, or what people call visitation.
Great. Well, thank you. Appreciate your time. And if anybody listening would like to talk more with Erica about this situation or a similar situation, reach out to Traub Associates and we can set up a consultation with her. Thank you very much again for today. We'll see you next one.